All right, welcome everybody. My name is Steve Wormeal and I'm your co-host and moderator today. And before we turn our attention to what I think will be a wonderful panel discussion on protest and free speech, it's my great honor and privilege to introduce Reginald Turner, who is the president-elect of the American Bar Association. He is a lawyer with the firm of Clark Hill in Detroit. He's has an extensive record of litigation, of client advising, of government experience in the federal government, and many, many, many years of widely respected leadership in the American Bar Association. And so it's a great pleasure to welcome Reginald to give us some opening remarks.
Thank you very much, Steve. It's really a privilege to be here and to have an opportunity to help you celebrate Constitution Day, a day so fitting to hold a program on freedom of speech, one of the first fundamental freedoms in our great democracy. Today marks the 233rd anniversary of the signing of the United States Constitution on September 17, 1787, by delegates at the Constitutional Convention. The annual Constitution Day commemoration gives us the opportunity to reflect on our nation's founding document and its critical role in establishing our rights and liberties. The principles enshrined in the Constitution connect all Americans as the framework of our government and means of advancing the rule of law. This great document that is over 130 years old is regarded as the bearer of our common beliefs and values. Yet the written words only have power if we protect, uphold, and exercise our rights. The last few months across our nation, there have been widespread protests and demonstrations speaking out in response to racial injustice, systemic inequities, and a threat of violence by law enforcement. These acts of freedom of expression have triggered a debate about the scope of free speech rights. As this program description probes, when are demonstrations within the scope of the First Amendment, and when do they exceed constitutional protection? When are law enforcement officials abusing the rights of protesters, and when are they lawfully trying to restore order? These are tough matters and very real concerns from all sides. So I thank the esteemed panelists gathered for this program who will tackle these pressing issues for what will undoubtedly be an engaging discussion. Thank you also to the numerous co-sponsors of this program and to our viewing audience, without whom we could not have this critically important dialogue. So I turn this program back over to you and look forward to the conversation at hand.
Thank you so much, Reggie, and thank you for being here. And it's wonderful to have your input on such an important topic and such an important day. We appreciate it, and we look forward to you doing great things as a president of the ABA a year from now. Let me say a couple of thank yous and then do some introductions, and we'll jump into things. Let me thank the ABA section of Civil Rights and Social Justice and its wonderful staff, Paula Shapiro, Ali Kilsgard, and Rushika Sharma. And I actually think it was Rushika's idea to do this panel, so we should give credit where it's due. And then let me thank the Washington College of Law Program on Law and Government, where I work as a professor of constitutional law, and its director, Fernando LaGuardia, who has supported this effort. We wouldn't be doing this without all of those folks. I just wanted to reflect for 1 second. This is an appropriate topic, it seems to me, for Constitution Day, because the founding fathers were protesters. As I was thinking about saying that today, I went back and actually did a little bit of research to look up some numbers. 7 of the signers of the Constitution had signed the Declaration of Independence, which of course is the ultimate protest document. But maybe even more interestingly, 27 of the 55 people who went to Philadelphia for the Constitutional Convention, 27 of them fought in the American Revolution. And so what we're talking about today, protest and free speech, I think relates directly to the heritage of our Constitution and to Constitution Day. Let me do some introductions. Ellen Rosenblum is the Attorney General of Oregon and has been since 2012. She is the first woman to hold that office. She served as an assistant U.S. attorney in Oregon for a number of years and then had a remarkable 20-plus year career on the Oregon state courts at several different levels of the state courts. And now serving as Attorney General, she will talk to us about her experiences in lawsuits involving the protesters in Oregon. Roy Austin is a partner at Harris, Wiltshire, and Grannis in D.C. He has extensive experience as a civil rights lawyer and litigator, and also previously spent 20 years in the federal government, including as Deputy Assistant Attorney General in the Justice Department Civil Rights Division, where, and apropos of today's discussion, he worked, among other things, on a number of cases involving police department practices. Ahmed Davis is a partner in the Washington office of Fish and Richardson and a very accomplished intellectual property litigator. He is chair of the firm's National Diversity Committee. And he decided some months back to use his considerable litigation expertise to get involved in representing protesters in Minneapolis after the murder of George Floyd. Scott Michelman is the legal director of the American Civil Liberties Union of Washington, of DC. He has litigated a wide range of civil rights and civil liberties issues involving all amendments that one might consider litigating over, I think. And he previously worked at Public Citizen Litigation Group. Before that, at the ACLU Criminal Law Reform Project. And Scott has been very involved in the DC litigation over the handling of protesters in DC. And last, but certainly not least, my co-host is Claire Rajan. Claire is the co-moderator for this panel and also co-chair of the Free Speech and Free Press Committee of the ABA section of Civil Rights and Social Justice. She is a lawyer at Allen and Overy in DC, and I'm proud to say she's my former student. And with that, I'm going to turn it over to Claire to get us started.
Thanks, and we don't need to say how long ago that was, but so thank you, President-elect Reggie Turner. Thank you, Professor Wormiel, and many thanks to our fantastic panelists, and of course, our audience for tuning in. A couple of housekeeping matters. So during today's program, we encourage you to ask questions of our panelists. Please use the Q&A function, not the chat function. If you don't see the controls, just make sure your screen is not on idle. We'll address questions at the end of the panel, and we'll be sharing a recording of this program to everyone who's registered so you can share it widely within your networks. Also, you'll see that we don't currently have closed captioning. Closed captioners apparently are in high demand at the moment. And so we are working on getting that fixed, and the video that will be available afterwards will definitely have the closed captioning. So we thought we'd start, we will come to some questions about the particular cases that our panelists are working on, but we wanted to start with some opening remarks from each of our panelists to describe your thoughts on the current protest movement and the implications for the First Amendment freedoms of speech, press, and assembly. So if you could please keep your comments to about 2 minutes. I can't kick you under the table in a virtual format, so we'll have to self-regulate. But Roy, could you start us off with a short introduction, please?
So thank you so much, and thank you so much for this panel. And look, we are in an amazing moment to be having this conversation when just yesterday our Attorney General talked about the protest movement and likened it to sedition. It is unbelievable that this is where we are Steve, I suspect that our founding fathers would not be considered peaceful protesters at the same time. And so making that reference is huge. So I come to this from a variety of points. One is I represented a young woman who was among the over 200 people who were prosecuted by the DC U.S. Attorney's Office for protesting the inauguration of our current president. That entire prosecution has been a mess and a nightmare for them. And fortunately, after almost 2 years, the federal government dismissed all those cases. But this was the federal government overstepping and really trying to chill the speech of numerous people who were against the inauguration of the current office holder. Now, I also come to this as a police reformer. And as a police reformer, I am someone who believes that our police departments are necessary agencies, but that they very much need to better be trained, better understand, have better policies in place to know how to do the work that we ask them to do. And nothing shows that better than the reaction of a number of agencies to what was happening with respect to peaceful protesters. Now, when I was with the Obama-Biden administration, we sought to limit the use of militarized weaponry by our law enforcement, in large part because of the reaction that they had to the Ferguson protests. And yet again, we repeat history, and we see this militarization that really exacerbates the problem. The other piece of it that I just think is important here is, look, Martin Luther King at his time was not considered a peaceful protester. And now the right and the left laud him for his efforts. I think what we have to understand is whenever we have peaceful protests, there will be people who will try to get in the middle of those protests and to cause trouble, and not the good trouble that John Lewis talked about, but just cause trouble. We cannot, and especially when we just had a report that said that 93% of the protests that happened in this country post the killing of George Floyd were peaceful. We cannot allow the few who choose to turn those protests into any level of violence or vandalism to prevent the protest from happening in the first place. And everyone needs to come to an understanding of that. So I appreciate the invitation to be a part of this panel, and I look forward to hearing from the fellow panelists and those who ask questions. So thank you.
Thanks, Roy. General Rosenblum.
Thank you so much. Happy Constitution Day. It is such an honor to be included on this panel and to get to see my friend who will next year become the president of the American Bar Association, Reginald Turner. And thank you to Steve and Claire and to all my panelists. In talking about the current protest movement and the implications for First Amendment freedoms, I'm going to talk about Portland. Until last week's wildfires made the air here unbreathable, and unfortunately that continues, and thus put a temporary halt to outdoor activities, we had significant protests every day, often in more than one location, from the day George Floyd was killed. That's basically 100 days and nights of protest. We've had huge peaceful rallies. We've had skirmishes with white nationalists. Our police have been challenged to put their conduct in the best light. We've been invaded by federal troops sent in as political theater by the president. We've had parts of our downtown boarded up like many other cities. We've had fires in dumpsters. We've had more tear gas and flashbang crowd dispersal tactics than anyone would want to deal with. We've even had the midsummer installation of a new district attorney who's a reformer here in Multnomah County. And don't forget the pandemic. So if you want a petri dish, a sort of laboratory, if you will, for questions of First Amendment protections, we're it, Exhibit A. Every single element, freedom of speech, freedom of press, the right of people peaceably to assemble, the right of people to petition the government for redress of grievances, even the exercise of religion are at play here and have been in the lawsuits that have been brought, which I'll discuss when we get to that section of the program. From my vantage, the key to any analysis of what's at stake here is this. Our protests themselves are directly about policing. This makes today's protests qualitatively different from other types of protests, say against the Trump administration's Muslim ban or opposition to a war. That is, when protests are marching, assembling, protesters are marching, assembling, and speaking against the very police force that's trying to limit their activities, constitutional tensions are heightened. So in that context, I just want to have a couple of thoughts and then we will move on. First, federal authorities have no business occupying our streets at this moment. So I'll talk about that. Second, I don't think our police authorities have understood what it means that they're the ones being protested against. And third, while these protests continue, human beings on both sides are going to cross lines. And so our community is walking a real tightrope as we try to ensure that protests remain safe and peaceful while helping our people express their overwhelming sense that we need change. Thank you for having me. I look forward to the discussion.
Thanks very much. Ahmed, would you like to go ahead?
Sure. Good afternoon, everyone. This no doubt has been an unprecedented year for all of us. If you had spoken to me on New Year's Eve and suggested to me a lifelong professional patent litigator that I would be participating in a Constitution Day webinar on free speech, I would have scoffed and kept walking, because this is far beyond the scope of what I have typically done. But at the same time, I am an African-American man in the United States of America. And at the same time, I recall clearly during my sophomore year of college, seeing what was happening in Atlanta in 1992 when the Rodney King verdict came down. And so when the opportunity arose for me to participate in a pro bono matter that I viewed of utmost importance this year, it was an issue that I didn't feel like I could pass up. All of us, I think on some level or another, were moved in many ways beyond comprehension when we saw the video of what happened to Mr. Floyd. And our firm, while our core competency is in intellectual property, also has always had a spirit of giving back on a pro bono level. And I personally believe in the mantra that to whom much is given, much is required. And when we had an opportunity to pair with the ACLU of Minnesota and work on this matter, it was simply an opportunity that I felt like I couldn't pass up. And so I am here as much to learn as anyone else who is participating in this great program. And as I reflect and think on exactly what it is we're going to be talking about and the importance of it, I am reminded of the words of James Baldwin, who said that, in fact, I love the United States of America more than any other country in the world. And it is precisely for that reason that I demand the right to criticize her incessantly. And at the end of the day, that's really what this is about. As the Attorney General said, we're going to be talking a lot about what individuals are doing, but at the end of the day, we're talking about people's right to gather and express that exact sentiment that James Baldwin talked about. And so this is an incredibly important webinar. It's an incredibly important topic, and I'm honored to be here and to learn from everyone that I see on my screen. It's a pleasure. Thank you.
Thanks very much. I think it's great for people to see that you don't have to be doing these things 100% of your time or 100% of your career to still find ways to take action. So thanks very much. And Scott, turn to you. And I think you're on mute.
Caught it. Good. Getting better at the Zoom. Still working on it. Thank you very much for inviting me to participate in today's event, which I think comes at a critical time for our First Amendment and really all of our constitutional rights, and for inviting me to participate with such distinguished panelists who have done so much in defense of our First Amendment freedoms. The First Amendment is under attack today like we probably haven't seen in my lifetime or any of the lifetimes of the folks here. And I'll join Claire in not speculating on how long any of those lifetimes are, but suffice to say that things are in a dangerous place. And I come to this as both a police reform litigator and as a First Amendment litigator. I see our protest work here at the ACLU of DC as having, in some sense, bookended the Trump administration, or what I'm going to hope is bookending it from the perspective of the respect for constitutional rights. In that, at the very beginning, as Roy mentioned, we had the Inauguration Day demonstrations resulting in a mass arrest of over 200 people, excessive uses of force, unconstitutional conditions of confinement, overzealous prosecutions, which Roy and many others stepped up, offering pro bono services to defend demonstrators arrested and charged for no good reason. And as Roy mentioned, the vast majority of those were ultimately thrown out after 2 jury trials resulted in 0 guilty verdicts. Our role at the ACLU of DC, in addition to supporting the criminal defenses to the extent we could, was to file a civil suit on behalf of protesters who were wrongly arrested, assaulted with excessive force, and denied appropriate conditions of confinement on January 20th. That matter is still under litigation against the District of Columbia because of the long history, not just here, but going back decades, of police abuse in certain large protest situations. Fast forward 3 years, and I was shocked. We were, I think, all shocked to see the events that unfolded at Lafayette Square Park in front of the White House on the evening of June 1st, where I got up from watching the video and literally was saying, what country are we in? What kinds of principles do we still hold to when civil rights demonstrators are attacked unprovoked and without warning by federal troops with weapons, some weapons of war? We learned today that even more weapons of war were contemplated. The idea of microwaving the protesters' skin was on the table for this administration. And it's just a shocking moment that I think will live in infamy in our constitutional history, when civil rights demonstrators in front of the White House protesting police brutality and systemic racism were set upon for no constitutionally valid reason, and the protesters forcibly dispersed from one of the most important sites you can protest in the United States, then aided and abetted, as we subsequently learned, by the DC police. So I come to this from several years of fighting back against the erosion of our civil liberties, particularly in the realm of freedom of speech, and in the context of an administration that has shown repeated contempt for many provisions of the Constitution, but freedom of speech in particular, from contempt for protections for the media to contempt for protections for protesters, the rights of assembly, and in general, just does not believe that people can take to the streets to protest maybe anything, but certainly not its policies. And that's something that we at the ACLU stand strongly against, and we think all Americans should stand strongly against, so that everyone has the right to voice their opinions freely and without harassment from the administration, the government at whatever level, and of whatever political persuasion. So thank you again for having me on this panel, and I look forward to the discussion.
Thank you. And I think that's a powerful way we've set up the beginning of this discussion. So thank you, everybody. This first question is for General Rosenblum. So there's been a flurry of activity, as you mentioned, in Oregon, a petri dish, I think is the term, in terms of cases brought, including one by you, to prevent protest suppression tactics being used against Oregonians on First and Fourth Amendment grounds. Could you just describe for us the claims brought and the posture of the current litigation in Oregon, how that sits right now?
Absolutely. Thank you. I'm even more honored now that I know we have these great lawyers in mind. So if I don't get into the weeds on the legal distinctions of the First Amendment, it seems like we have plenty of brain power here to do that. But I hope I gave you a sense in my opening about how I feel about this issue and why I've taken 3 main actions. Mainly, I'll be talking about the lawsuit. So we sued the interloping federal authorities, as you know, to stop their First Amendment violations and to encourage them to leave town, which they did. Yay, finally. Second, I've worked with the People of Color Caucus at my legislature at some special sessions we've already had this summer to achieve significant police reforms, just as I had earlier worked to achieve reforms in police profiling and hate crimes. And third, I've added my voice to that of other leaders, both in Oregon and across the country, supporting the protests, but decrying the violence that has occasionally been associated with it. So getting to the lawsuits, because after all, most of us on this call, I think, are lawyers. And this is just such a great section of the American Bar Association. So thank you for participating. The federal policing of Portland protests this summer really was a disaster in many respects, and it led to no fewer than 5 lawsuits. So I was actually only directly involved bringing one of those. So that was the Oregon Department of Justice, which I lead, and I brought the lawsuit after it came to light that federal agents, and you heard about this, you saw it on TV, without identification were pulling Portlanders off the street into unmarked minivans. And so we asked a federal court to require federal agents to identify themselves and explain what they were doing when they were making these arrests. These were peaceful protesters. These were not people that were engaging in violence. The one gentleman who became the best known, Mr. Pettibone, was just literally on his way home, walking home from the protest. So even though federal appellate courts have said that the Fourth Amendment requires law enforcement to identify themselves, unless there's good reasons why they can't, these federal officers were refusing to do that. And on top of that, they had these unmarked vehicles and they were taking people who knew where. It turned out they were probably mostly taking them to the federal courthouse and then most cases letting them go, in some cases holding them. Basically, they appeared to be adopting impermissible methods for the specific purpose of intimidating protesters, which we assert is inconsistent with the Fourth Amendment's limits on state violence and with the First Amendment's protection of the right to protest. So though their conduct was highly concerning, I was at least as troubled, frankly, by their reasons for coming in the first place. Specifically, these armed federal agents seemed to be here for 2 equally impermissible reasons. The first was to inflame what were already high tensions for the president's perceived political gain. And the second was to make a show of dominating. And remember, they used the word dominating when they came, the fabricated chaos, because it really wasn't chaotic till they got here. There had been some moments, but for the most part, these were peaceful protests and they were getting resolved. We were actually moving to a good point when they arrived on July 4th or just about that date. So the overall appearance was that armed federal agents were using unlawful violent tactics on the streets of Oregon in pursuit of an unlawful mission. And, you know, I vehemently disagree with the preliminary suggestion by the federal judge in our case, suggesting that Oregon lacks standing to pursue a remedy under the circumstances. So, you know, we brought a TRO and that TRO was denied on lack of standing. You know, the judge actually agreed that our evidence established a presumptively unlawful arrest, but he ruled on a different ground. So, but you know, my point was if our sovereign state does not have recourse to the federal courts to adjudicate whether armed feds forcibly rounding people up within the state borders are or are not acting within their lawful authority, that suggests that really any remedies would have to be pursued extrajudicially. If the state doesn't have standing, who does? Well, the judge said the individual protesters have standing. He said some really odd things. He said the remedies we are asking for are illusory for some of the harms that we had identified. He had just a lot of problems with our claims. But nevertheless, we feel like we won. And by the way, yesterday, we dismissed the case without prejudice because we feel that the conduct has stopped and we didn't feel the need to pursue the matter further at this time. So I wanted you to know that we actually did get to a good conclusion, and the federal agents, as far as we can tell, for the most part, have left the city. And that is a very positive thing too. We still have lots of issues with local police. I'm not saying that everything's just hunky-dory. It's not, The protests continue, but for the most part, they continue for the right reasons. So briefly, let me mention, do I have time to mention the other lawsuits, Claire? I don't want to overuse my
Sure,
5
go
minutes.
ahead. Yep.
Okay, so the other lawsuits relate to sort of equally troubling aspects of this federal action. One brought by the ACLU, thank you to the ACLU, alleges that journalists and legal observers had been targeted for violence by law enforcement officers. And the district court judge in that case, Judge Simon, entered a restraining order to protect plaintiffs, citing evidence of circumstances in which plaintiffs were identifiable as press, were not engaging in unlawful activity or protesting, were not standing near protesters, and yet were subject to violence by federal agents. Unfortunately, this order was subsequently stayed by a Ninth Circuit panel with little explanation. But the evidence supporting the injunction in the first place should certainly trouble everybody. And perhaps our Scott might have some other comments about the journalist lawsuits. A third suit alleges that federal officers were targeting protest medics, sometimes as those medics were providing treatment to protesters who had been injured by federal officers. And again, the allegations were extremely troubling. For example, plaintiffs cited occasions where they were shot with rubber bullets, providing aid to downed protesters, and beaten with batons while helping an injured elderly protester through the crowd. The district court judge in that case rejected a temporary restraining order, asking that medics be exempted from dispersal orders when actively providing treatment to protesters. The judge suggested that granting this relief would grant medics greater First Amendment rights than others, and that medics could not be identified reliably. A fourth lawsuit, there's just 2 more real quick here, brought by a nonprofit, a church, and 2 Oregon lawmakers, state lawmakers, argues that under the 10th Amendment, the federal government lacked authority to engage in the extended policing of the Portland protest. And then finally, I'll move on because that wasn't the First Amendment case. Finally, 7 plaintiffs filed a suit in the District of Columbia that alleges both that the conduct of federal law enforcement officers violated the First and Fourth Amendments of the Constitution, again, by deploying unlawful force for the purpose of quelling lawful protests. And they also alleged that the entire enterprise of deploying federal law enforcement for the purpose of quelling the protests violates principles of federalism by essentially usurping state police powers. And I did want to just mention that case I mentioned that involved a church, that actually also alleged an Establishment Clause violation. So that was not just a 10th Amendment case. The members of the Unitarian Church alleged that acts of federal officers were preventing them from practicing their religion by making them fearful of coming to protests to provide support for the protesters. So that's how they brought religion into it. However, I'm not sure they got too far with that one either. So the lawsuits themselves have not been particularly successful so far. Some of them are still pending, but I think that we have made some really great points. We have been able to assert our First Amendment rights to bring these lawsuits and to raise these issues, which absolutely have to be raised because we have to be able to get back to the main purpose of these protests, which I believe for the most part we have. Thank you.
Thank you, General Rosenblum. It's fascinating to hear all the maneuvering and all the legal issues. I'm going to turn to Ahmed and sort of pose a similar question. You've told us a little bit about how you decided to get involved in Minneapolis, but tell us what you've seen and heard and where the lawsuits stand.
Sure. Thanks, Steve. I'm going to take a step back, though, and kind of paint a larger picture of what's happened and what is happening in Minnesota, because there are multiple lawsuits that are going forward, and we are involved in just one. And I might not get the exact order in which they were filed correct, but the overarching theme of each of them is the same, and much in the same way that the Attorney General described. The causes of action are based in violations of First, Fourth, and 14th Amendment rights. And there are 1983 actions that have been filed against the Minneapolis police, the Minnesota State Police, as well as specific lieutenants and John Does within those forces. The first one that was filed, I believe in early June, was the Goyette case, That's a class action case that was filed specifically seeking to protect the rights of the press. Many of us saw what happened to Omar Jimenez, for example, who was arrested live while reporting on CNN. Ali Velshi from MSNBC was fired upon directly by the Minneapolis police and was shot. And there are a number of individuals who are identified in the Goyette complaint. The most notable being a reporter, a journalist named Linda Tirado, who received, actually lost sight in her left eye after being shot with a non-lethal weapon in the eye. And so she filed a separate suit as well. That Goyette case was filed by the ACLU and with another law firm. We filed second on behalf of the class of plaintiffs who were protesting peacefully in the wake of George Floyd's death, but not any reporters or anything of that sort. And so the complaint itself tracks very closely the Goyette complaint. And essentially, we identified kind of three general groups of protesters, peaceful protesters who were targeted. Those who were there sitting peacefully and were fired upon by Minneapolis police as well as Minnesota State Police. There were those who received dispersal orders but were then fired upon immediately before they were given an adequate time to disperse. And then there are individuals who you may have seen after the dispersal orders were given, who were actually on their porches and were effectively on their own property and were still fired upon by the Minneapolis police and the Minnesota State Police. And so the first lawsuit was assigned to Judge Wilhelmina Wright, and there was a motion for a TRO that was filed in that case. The judge denied the motion essentially on the grounds that, at least at the time that she heard it, there was no suggestion that there was a likelihood of a repeat of what was happening. She acknowledged the gravity of the allegations in the complaint, but she nevertheless denied the TRO without prejudice. And she also denied the request that she certify a class at that time. Our case, the Armstrong case, was assigned to a different judge. And then about 3 weeks later, that's Judge Susan Richard Nelson. About 3 weeks later, a second class action lawsuit was filed, specifically identifying a distinct set of protesters, and that included allegations from those who were impacted on Interstate 35. If you recall seeing the video of the truck that drove up through the protesters. And shortly after that case was filed, it was, I forget the judge that it was assigned to, but it was identified as a related case with ours. And so it has been reassigned to Judge Nelson. And in both our case and that class action case, the answer date is coming up, I believe, the second week of October. And so then we'll be moving forward. Separately, in addition to Goyette, Armstrong, and the Samaha case, which is the one I just mentioned in Toronto, there's of course the George Floyd wrongful death suit itself that has been filed that sets forth many of the same allegations and the context for these cases. Across all of them, what we see over and over again are what, in my view, are just abhorrent actions as alleged by those who were protesting on behalf of the Minnesota State Police and the Minneapolis Police. The language and the threats that were made against the protesters, against the press, really were done without regard for anyone or anything that was going on. There was no attempt that was made, according to our clients and the plaintiffs in those other cases to try to discriminate or distinguish between individuals who were kneeling and praying, individuals who were locking arms and singing, and those who may have been doing things that don't fairly fall within the scope of peaceful protest. And so, you know, we're hopeful as we move forward that there will be a very distinct and clear understanding that, you know, there were protesters out there who were not engaged in anything other than their First Amendment right to peacefully protest. And I think that the word that we heard at the beginning was something like 93% of these were peaceful. The lawsuit that we filed is about those 93%. I don't know that there's anyone who is on this webinar who is going to defend some of the actions of those who we see committing crimes. But this is about, from our perspective, and the reason that we got involved is about defending the right of those who want redress of their grievances and want the right to express themselves without being fired upon by the police indiscriminately.
Thank you, Ahmed. Very, very powerful. Scott, you've been on the front lines of the litigation in DC. Want to give us a little update on what's happening there?
Absolutely. So, like I said, on the night of June 1st, when the Lafayette Square attack occurred, we were immediately thinking about legal theories, thinking about plaintiffs, reaching out to our allies. Within 72 hours, we had a complaint on file, with working together with the law firm of Arnold and Porter and the national and local offices of the Lawyers Committee for Civil Rights. We filed a suit on behalf of Black Lives Matter DC. It's captioned BLM DC versus Trump. We sued Trump, Attorney General Barr, who was on the ground and who gave an order that the protesters be cleared from the vicinity of Lafayette Square. We sued the head of the Park Police, and we sued the heads of several other agencies whose officers were there and participated in the use of wanton force, tear gas, rubber bullets, baton charges. We've all seen that video of the Australian reporter getting beaten and her cameraman beaten with batons. We've heard congressional testimony now from one of our clients, Keyshawn McDonald, an African-American and a U.S. Navy veteran who was there and who knew, you know, enough about riot control tactics and law enforcement tactics to understand what he was witnessing, and that it violated all military rules of engagement because the force was so unwarranted in the situation that he was seeing unfold, and who felt like, you know, having served his country, he was now being repaid with violence and a denigration of his rights. We heard from congressional testimony from Marion Buddy, the Archbishop of the Episcopal Diocese of Washington, who described members of her church ministering to the injured on church property, on the steps of the church that the president would shortly visit after the violence, who were chased off of church property by federal forces. So really, in many ways, a perfect storm. You've heard me mention press, religion, speech, and association. It's like, you know, it's like the federal forces on that day were ticking through the parts of the First Amendment and making sure they struck at each one. They couldn't have done it better or worse from our perspective. So we had that case filed very quickly on behalf of Black Lives Matter and its members. Several individuals, including Mr. McDonald, including also Tony Sanders, who was there with her wife and her 9-year-old stepson, who subsequently asked, after they fled from tear gas, who subsequently told his mom, "Don't go to protests. I don't want you to die." A 9-year-old boy worried that going to protests in the United States of America was a life-threatening activity for his stepmom. We sued on behalf of Leah Poteet, who was beaten by an officer on the front lines of the charge, a federal officer. And then when she reached down to pick up her cell phone that had been knocked from her hands. She was beaten again when she was on the ground. She was struck in her knee where she had ACL surgery. So I highlight these stories just to give some of the human aspect of this. People from all different walks of life, Black, white, different backgrounds, different places that they live throughout the greater DC area, coming together with Black Lives Matter and so many other groups to protest systemic racism and police brutality, and having some of that same brutality visited upon them in tactics that are really reminiscent of Bull Connor and the villains of the civil rights movement in the 1960s, dispersing protesters with rampant and wanton violence. We sued under several causes of action, including the First and Fourth Amendments. We subsequently amended to include DC police, who denied they were involved, but then video came to light showing that they were in fact stationed just 1 block away from Lafayette Square, where they were in formation shooting tear gas at fleeing demonstrators. So they were fleeing the federal action right at Lafayette Square, and were chased right into the hands of DC Metropolitan Police, who then further fired on them, injuring another one of our clients. So really from top to bottom, an incredible denigration, an obvious violation of the First Amendment rights of speech, assembly, and others. The last point I want to make, well, I will give an update on the status of the suit, where we've worked to identify and name some individual officers to round out some of the allegations and include people at different levels, including the incident commander. And we're now moving into motions to dismiss that will be filed at the beginning of October, and we'll be responding to those, obviously. But I want to make this, to end with this legal point. We sought injunctive relief, and we know injunctions have been denied in other cases, though they've been granted in some. That's never an easy type of relief to obtain. And we've also sought damages, because there needs to be accountability for this gross violation of constitutional rights. But and to us, the Constitution is absolutely clear that this was a First Amendment violation. It is a First Amendment violation to break up a protest when demonstrators are not doing anything wrong, when unprovoked violence is visited upon them. It is also clearly a Fourth Amendment violation to effectively seize people with the use of this force by halting or forcing their movements. Again, unprovoked, no probable cause, no reasonable suspicion, just gross violations that I think, someone mentioned the founders, I think Steve at the beginning, they would have been appalled to see this type of action. There is no question, I think, this violated the Constitution. And yet there are powerful defenses available to the defendants, arising out of the limitations on Bivens remedies and arising out of the defense of qualified immunity, that makes this not a slam dunk case. I mean, we think it is a highly meritorious case, and we do think we have the better of the arguments on the motion to dismiss that we anticipate coming. But let's pause for just one moment and note that this shouldn't even be a question, right? But the federal defendants will argue, one, you can't sue us because we're federal officers, and most of the time federal officers, there's no cause of action under the Bivens doctrine that has been cut back. And then they'll say the right wasn't clearly established with the requisite specificity, so we are entitled to qualified immunity. And those, maybe procedural isn't the right word for it, but those remedial doctrines, or those substantive adjacent doctrines, those non-merits doctrines, too often determine the course of police accountability for gross misconduct. So even though we have a constitutional violation that basically any thinking person would understand and observe and affirm occurred just based on watching those videos, we're going to have to overcome some very powerful defenses, and it speaks to the necessity of reforming some of those defenses so that there can be real accountability and deterrence for violations of the Constitution.
Thanks. So on that topic of reform, actually, before I get to my question, I see we're getting a number of comments and questions coming through the Q&A. Please keep them coming, and we'll be building that into our questions. So thank you. But on that topic of reform, Roy, I'll turn to you, because in your career as a prosecutor and in the Civil Rights Division, and you're assisting on policy in these areas. And so here's a softball. How do you think we can strike that right balance between allowing the peaceable exercise of constitutionally protected rights and ensuring that law enforcement has the tools it needs to prevent and prosecute illegal conduct? Is it a matter of training? Is it different policies? Do courts need to be more proactive, or is it the accountability through defenses that Scott's referring to?
So, you know, it is in fact a softball, and the answer is stop violating people's rights, period. I mean, that is really what all these protests are about. That is the answer to the question, is we cannot have law enforcement violating people's rights. And I think General Rosenblum, you know, she nailed it on the head when she noted the fact that we are protesting police violence, and those protests are being met with police violence. So the police are proving the premise of the protests, is what I see happening time and again. But we can get a little bit more specific. Now, first of all, when you have law and order rhetoric encouraging, emboldening the violence that we're seeing from police officers, that's where the blame for some of the out of control nature of some of these protests really should lie, is because you are the match setting fire to tensions that are already high. Instead of, you know, we ask our police officers to de-escalate. Instead of seeing a White House seeking to de-escalate, we see a White House who, and I think again, this was General Rosenblum talking about the fact that this White House seems to think that there's some political gain by riling up these protesters, and just keeps doubling down on that riling up. So we have to teach de-escalation. This administration destroyed something called the Community Relations Service, a group that is known as the peacemakers of the Department of Justice, who were created based on the protests of the Civil Rights era. They have the skills and the ability to go in, bring the sides together, talk to the protesters, talk to the police, set rules of engagement that have been successful for decades on allowing the peaceful protests, while at the same time ensuring that the police know kind of how to police these things in a way that keeps everybody safe. We need to stop rolling into protests with weapons of war. First of all, these are the streets of America. We shouldn't be seeing this to begin with. But we know when the police are being told that you are about to do battle with your fellow Americans, that they're then going to do battle with their fellow Americans. We saw images, I saw this in the Washington Post, they talked about how a protest got out of control. And it showed some protester, I believe it was a protester getting, basically throwing water at a police officer, okay? Should that have happened? No. But then for the entire police force to then bum rush the protesters based on that incident is what caused the further violence and the further damage and got more and more people angry. The tools that the police have at their disposal to prevent these things from becoming violent are innumerable. And when you have the vast majority of people who simply want their voices to be heard, then they have to allow those voices to be heard. And that's what's not, that's the problem that we're seeing here. And so we have poorly trained police departments who refuse to acknowledge that it is this systemic violence that people are seeing there that has to stop, that is leading us to what we are seeing there when things go astray. But again, we are emphasizing, look, police get mad when you talk about a few bad apple police officers are the ones who are violent toward the citizens. But now we have, let me use the same terms. We have a few bad apple protesters. Okay, but will the police then allow us to say it's a few bad apple protesters? And no, they want to use that. They want to use the term of violence and vandalism against all these protesters, but they won't allow that to be used against them. Well, that's the hypocrisy that we are seeing yet again. And so much of the blame. I mean, we didn't see these protests. We haven't seen these protests since the civil rights era. What is the difference? We have a president and an administration that talks about law and order, that is encouraging violence by police officers, that refuses to hold police accountable when they are violent. That is what the difference is here. And that's why we're seeing these protests. And so until an administration comes in that is willing to bring both sides to the table and willing to have adult conversations with both sides, we're going to continue to see this. And so it's more than just training. But look, the bottom line and the answer to your question is stop violating people's rights. And then people won't have something to be protesting about.
Thanks, Roy. I spent, before I became a law professor, I spent 20 years as a journalist. I'm going to date myself now, but I covered anti-Vietnam protests. I covered other kinds of protests in the Boston area and in DC. No law enforcement official ever threatened me or harassed me when I was covering a protest. I'm flabbergasted by what we're seeing in the attacks on journalists, the physical attacks on journalists. And so, to anybody on the panel, why is this happening? What is different about this than periods in the past? Even in the civil rights era, the journalists were to a large extent able to keep themselves apart and to cover the protests. I mean, they got caught up in libel suits, New York Times against Sullivan and so on, but not so much physical violence against journalists the way we're seeing now. Any thoughts, anyone?
I mean, I think, Steve, to me, it's a short and a quick answer, and that is that we have seen a devolving sense of respect for the press more generally, and the physical attacks and confrontations that we see, I think, is a natural outgrowth of the verbal, arrows, slings and arrows that we've seen fired over the last 4 years. It's a natural consequence, and to me, I would say it's entirely expected.
I would add that this is not my belief particularly, but in terms of the arguments that were made here and the reversal of Judge Simon's opinion, there are those who take the position, the federal government at least takes the position that the journalists can't be easily identified. There's no such thing really as a journalist anymore. Everyone's a journalist, right? You're a blogger, you're whatever. Everyone takes pictures, so you can't be a journalist, photojournalist, because everyone takes pictures. So how do you distinguish? That was the same issue that came up with the medics case. I mean, it's crazy that you can't, that case even seems more severe in the sense that a medic, if it says medic on your jacket and it looks like someone's administering to the aid of someone who's injured, that would seem to be even more clear than in the case of a journalist. But I think that journalism has just morphed into, there's a lot less respect than there used to be, which is should not be the case. But, and I'm in a family of journalists, so I don't hold those beliefs, but I think that's part of what's driving that notion.
And I would just add quickly to what Ahmed and General Rosenblum said, that I think this is all taking place in the context of declining respect for the Constitution generally, and declining civic education. I think there's a growing segment of people who think the Constitution means whatever they say it means, or the Constitution only protects whatever they personally want to do. It doesn't protect their enemies. It doesn't protect someone who would criticize them. If somebody is wrong about their policies or their politics, they don't have any constitutional rights. And I think that starts with the president and flows outward from there. And so I think there's that example being set at the top, but also shared by enough people that it's possible for law enforcement officers in these situations either not to recognize or not to respect the constitutional lines that have actually been quite clearly drawn.
Thanks. So we've naturally been looking backwards and sort of looking at what's happening today, but looking forwards, and it's not too far in the future, towards the election. And I know the word unprecedented gets a lot of use these days, but I think it's fair to say it will be an unprecedented presidential election. There are a variety of issues that are getting teed up on who and how people will be who will be able to have access to the ballot and how those votes will be counted, how quickly. And there are serious questions being asked of whether there'll be a whole new wave of demonstrations, and with the corresponding potential for local police and federal response. And so what do you anticipate will be the issues coming up in only 40 or 50 or so days? And what actions do you hope the courts will take to protect First Amendment freedoms? And do you think that they should be doing more proactively in advance to do that? Happy to start anywhere, whoever wants to jump in.
Look, I'll start with this one. There will be protests, regardless of who wins. There absolutely will be protests. And law enforcement right now needs to be having a conversation on how they are going to police those protests, how they're going to look, what activity are they going to allow, what activity are they not going to allow, how are they going to intercede when people are acting violently. At the same time, mayors and city councils and others should be sitting down with everyone in their community who are likely to be the leaders of these protests. So everyone from Black Lives Matter to your local militiamen, to your faith leaders, to whomever it may be, and having a conversation about what kind of protests they're going to have, what they're going to do with respect to law enforcement, how to do these things peaceably, where these protests may or may not happen, but start this conversation, because this is the conversation that this country has not had for some time. And you can actually have a conversation between sides that completely dislike each other about how to do this in a way that is peaceful. But if you just sit back and you say, you know what, they're going to be protests and we'll deal with it when it happens, then there's going to be an explosion. And look, whoever wins, the other side is going to be very angry, And we need to right now be having that conversation about how we deal with this. And look, what the United States has always had is a peaceful transition of power. That's one of the few things that we have always had. And we need to ensure that that happens this time around. But it's going to take planning and it's going to take thoughtfulness. And we can't go into this thing pretending like it's not going to happen.
And this also implicates the issue of voter suppression, what's going on now, because the president has already stated that he's planning to have law enforcement presence at the polls. And he's trying to prevent people from voting by mail. He's trying to scare them into not voting by mail for reasons that are absolutely absurd. He's telling lies. He's, making it all up so that people will be forced to go to the polls if they do vote. And then when they are at the polls, there will be potential for protests and bad things happening, because he's already indicated that he's going to be calling out essentially the militia, which is what he sent to Portland. This was a police state here in Oregon, a federal police state for most of the summer because of him. So, I realize that the ABA is nonpartisan, so forgive me, but we need to be worried not just about what will happen after the election. We may not know who's won this election for months. we are going to have the potential for protests for many, many days, longer than they've been here in Portland. So we need to get ready now. We need to do what we can to bring lawsuits in advance for TROs, for various restraints, so that on election day, people can peaceably vote and feel safe waiting in line, which they may well have to do. Here they've got to worry about whether they're going to get COVID. On top of that, they have to worry about whether they're going to be, hit with batons.
Ahmed or Scott, any thoughts on that one?
I'll just weigh in and say that sadly, I completely agree with what Roy said. And I think it's just important that when he says there needs to be a conversation is bilateral, and it requires both speaking and listening. And when you hear some of the rhetoric that we've heard recently, I think it's challenging to have a productive conversation now in advance, but I really do think that it's imperative that those conversations take place, and not just that law enforcement have developed a plan for how to deal with this, but that it be implemented in the way that is planned, because sometimes it gets planned, but it's not actually executed in that way. And that's actually what we see, in the cases that are in Minnesota, because, the problem was the police weren't following some of their own plans.
Yeah, thank you. So one more question, and then we'll turn more to the audience questions. Should the freedom of assembly be viewed as its own independent right, or should it be viewed as derivative of the freedom of speech? And so if it is derivative of the freedom of speech, should that potential chilling effect of aggressive police tactics create an avenue for more advanced redress rather than only after the fact, or after the events have already taken place? So Scott, I'll turn to you first for that question.
Sure. Well, I think what is clear is that the Constitution does protect the freedom of association, both implicit in the freedom of speech and explicit through the freedom of assembly. And there's a long and critical line of cases reflecting a distinct role, a distinct and complementary role for the freedom of association as it pertains to the freedom of speech, because the freedom of speech, as you know, is magnified when it's done in community, in coalition, in mass protest events, and that's what we've been largely talking about here today. So I think they are inseparable in terms of their importance, but they are distinct in terms of the protection that they offer. So it is your right both to speak your mind and to assemble with others. Even if you assemble with others in silence, you are both sending a message by your silence, potentially, but also sending a message by your association. The way I read many of the law enforcement actions we've been talking about in Portland, in Minneapolis, in front of the White House, and frankly elsewhere throughout DC by both federal and local police all summer long, is that that law enforcement has not been distinguishing. They are going to break up these events in part because they're large, at times because they don't like what's being said, and at times through a sort of logic that we saw getting back to the Inauguration Day protests in 2017, through this idea of guilt by association, which is anathema to the Constitution under both the First Amendment and the Fourth Amendment. So the First Amendment very much protects the right of association, and also, as sort of a corollary to that, prevents the inference of guilt or of suppressibility, of the appropriateness of police action to one person based on the actions of another, unless those people are shown to be acting, in the words of the DC Circuit, as a unit. When that is not happening, then people have the right to speak, to gather, and to do so regardless of whether a water bottle is thrown by a member of the same crowd. And once we lose sight of these basic principles, that's when you get chilled from speaking or assembling.
We have a question from Fernando LaGuardia at the Program on Law and Government, which is, what can law professors, law students, and lawyers do to get involved in these matters and take action?
How about everything? You can do everything and anything. We need you. We have several people here who are affiliated with law schools. Of course, I would start with your bar associations that have pro bono programs. I would go to your law school clinic programs. I would go to the ACLU. I'll offer up Scott here for volunteers. It's a little bit harder for us to take in volunteers, but come and work for me. Help us out. We love civil rights lawyers in attorneys general offices these days. We no longer are just defending cases. We are bringing affirmative litigation, and we welcome you.
And I'll just add to that and expand a little bit in that we work with volunteer lawyers and pro bono counsel in various capacities, and we've been really moved and thrilled with the outpouring of support from partners, from volunteers who say, hey, my law firm just pushed my start date back 3 months. How about I spend the interim time working for you? Which is great, and not just at the ACLU of DC, but there's an ACLU in every state. That said, I don't want to make like we're the only game in town. There are tremendous partners doing work, and I can't name them all, but I will say, not only could you volunteer with a legal organization doing litigation, you could also volunteer to do various kinds of legal observing for protests or for voting. That could be with a local party organization. That could also be with associations that run legal observer programs. That in some ACLU affiliates do that. Some other very competent, very well-established organizations do that as well. So there are lots of different ways that you can get involved, even if it's just showing up to one protest, to be there, to be trained, to document police abuses, to be a witness if there's a conflagration. That provides value. And we've seen through the use of video, that is a serious check on law enforcement misconduct, because when it is brought out into the open, that changes the dynamic, that motivates people to be more on board with the need to do things a different way. And so there are a lot of avenues for lending your skills and your passion to the cause of protecting the Constitution.
And I'm going to do just a very short, friendly amendment to what Scott just said, and that is protest and vote. Okay, so you can be a protest observer, but there's nothing wrong with also being a protester, because that's what this is about, is protesting. And when it comes to voting, I mean, you know, we keep talking about the president, but the president only has, despite his own thinking on this, so much power. You need to be voting for your AGs. You need to be voting for your state and local DAs. You have to be voting for your sheriffs. And being a part of those elections at a different level are a huge part of getting this whole thing right. Because at the local level, I mean, there, 2,400 different communities had protests post the killing of George Floyd. Every single one of those communities has a city council, a mayor, a sheriff, someone who you should be voting for. And if you're voting for the person who is looking for solutions as opposed to creating more problems, that's incredibly important. And each of those people needs someone supporting their campaign and getting the message out that this person seeking election is on the right side of these issues. So that would be my friendly amendment to what Scott just said.
Accepted as friendly, absolutely.
And I would just chime in and follow on with, for those, I think the question that I saw was not only to law students, but also to lawyers. For those that are at law firms and maybe even be a junior associate or a mid-level, even if you're a person such as myself that really, this was my first foray into this area of the law at all. It's something that I felt compelled to do. And if you have a heart for it and you're interested, speak to the pro bono coordinator at your firm. And particularly in these days at this times, firms are uniquely aware of and interested in the need to do this kind of work now. The pump is primed, as it were, for you to approach people in your firm and say, this is something that I think is important and it's valuable and I'd like to do. And, you know, hopefully, prayerfully, that'll be received well.
I see a question that I think might be worth answering. It's how do we balance the rights of the protesters with the rights of the rest of the communities? As for the violent protests, 7% is not 7% not peaceful is a high percentage. Who's protecting uninvolved people for the damage and injury that follows?
Absolutely. People need to know, the community needs to know we're going to take action against those violent protesters. And we are doing that here in Portland. My office, for example, is assisting the police with their investigations because it turned out that they were so overwhelmed, frankly, with all the having to be out every night. They weren't getting any time off. Resources are slim. And so some of these investigations weren't even the more difficult ones, the ones that weren't the IPOs. Those are the interfering with the police officer. Those are the ones our DA said, no, I'm not prosecuting those, but I am going to prosecute the more serious cases, the ones that involve arson, the ones that involve other types of real violence. But there, you know, we don't have even that percentage of violence in Portland. It's a very, very small group. However, they make the loudest noise, and guess what? They get videotaped, and that's the tape that's running in the Trump camp. And, you know, somebody else asked a question of, you know, how do we know they're not going to come back? Well, how we know they're not going to come back is they didn't really do very well here. They brought the wrong people. They brought people who didn't know how to de-escalate. They brought the wrong people who actually made even the president look bad. So, you know, we are going after the ones who need to be gone after. And if we don't do that, then we don't, you know, then there's a problem, because we do not want to have violence in our communities, and we have to stop it. But you don't stop it in the way, unfortunately, some of the police agencies have demonstrated.
There are a few different questions asking about, and I think some people have touched on it briefly, but just asking about what it is people are being arrested for. And obviously, given this is a First Amendment conversation, how that Fourth Amendment, those issues tie into the First Amendment. And so people aren't being arrested necessarily for protesting, right? They're being arrested for different types of crimes, misdemeanors. We talk about, there are patterns that you're seeing. Are there ways that these other types of arrests are being made with the idea of suppressing peaceful demonstrations?
Well, I'll give you one recent concrete example from the streets of DC. And that is a curfew law. When a or even a curfew executive order, when a curfew is in place, it makes it much easier for police to arrest protesters who are otherwise doing nothing wrong, but whose very presence on the street has been deemed illegal. That's why curfew laws, I think, are very dangerous. We've seen some successful pushback against them, and some of them have been, sort of died down and rolled back of government's own accord. But I think it gives an enormous amount of discretion to the police when mere presence on the street becomes unlawful at that appointed hour. Then the police get to decide, which group of protesters are we going to arrest that look like which people, that are saying which message. That's a recipe for a lot of discretion, which I think is a recipe for discrimination, both based on viewpoint and based on race.
And look, Scott didn't say the word, but it needed to be said, Kenosha. Okay, we saw exactly what happened in Kenosha where they were enforcing the curfew against the protesters while the white militia was being encouraged to help them out, where they were there in clear violation of the same curfew, and not a single law enforcement officer decided to do anything about them being there beyond curfew, actually handing them water and encouraging them to stick around. And there's a whole part of the justice system that's known as procedural justice. And that is the idea that people will only be faithful to the justice system if they believe the justice system is being fair. And when you have blatant examples of the justice system not being fair, to expect others to in fact trust and respect the justice system is really asking for a little bit too much. So and the number of contempt of cop violations, and these are things where police officers just get mad because the person wasn't moving fast enough or the person turned around to ask a question. Those kinds of highly discretionary violations that the police enforce against one group or not another, that is what is helping to build the fire that is causing the violence that we see when we do in fact see violence.
And grouping a couple of questions, or trying at least to group them together, how do police departments learn about the protocol for particular demonstrations and what tactics to use and who's in charge of those tactics, and how do police departments relate to municipal government structure? I mean, if a mayor is condemning the actions of their own police department, it seems like maybe they should have been talking to each other. What are the lines of communication there? Anybody? I know, Roy, you've dealt with some of these kinds of problems, I think.
So, I mean, I have, and you know, the thing is that the training that police departments can have on this is available. We did this training in the COPS office post-Ferguson. There's the Police Executive Research Forum that does this training and talks about these issues. There's the International Association of Chiefs of Police that provides this training nationwide. We have the examples of what happened in a number of cities and municipalities, that smart police officers, chiefs will come together and come to ways to deal with this. But look, the police already know that there's going to be discretionary, that DAs and Commonwealth's attorneys and state attorneys are going to use their discretion to decide which crimes are going to be enforced and to what extent they're going to be enforced. That discretion exists across everything else. So for them to get mad that discretion is being used with respect to protest is simply kind of imagining a different world that we live in. The discretion exists and it will be used. You just have to set up rules of engagement. You have to have these discussions about, this is what we're going to do when we see certain behavior, and this is how we're going to deal with it. But again, it's not we're going to come in there with shields and body armor and tear gas and the microwave tool that they started talking about. That's silliness and craziness, and you get the results that you get when you start doing those things. And so what they are doing right now is they're going in there short-sighted without a plan. And then I think Ahmed pointed out, half the time when they have a plan, they choose not to follow it. And so you have to have real leadership to make sure that the police, and look, police deal with people who are not following the law on a regular basis. You don't beat every single person who you see not following the law. You don't shoot every single person who you see not following the law. You don't spray tear gas on every single person you see not following the law. You have tools, and you use those tools, and you use them appropriately, and you use them fairly. And that's what they need to do. Thanks,
Roy. So to go from the sort of powerful to the mundane, I'll give you the CLE code. If you didn't see it, it's 353890. And I think we have about 6 minutes left. And so it'd be great if maybe we could just get a minute for everybody to give their closing thoughts on the many topics we've discussed today. And General Rosenblum, if you'd like to kick it off.
Thank you so much. Well, I actually did want to just add to that discussion that we just had, that it was so interesting that we also have to keep in mind that, the laws that are on the books may not really be any good anymore. We may need to actually take a look at some of those and make some changes. It may be that I referred to IPO, interfering with a police officer. That's what most of the charges that our police were arresting people for were. Maybe we need to take a look at that and decide that that's no longer a good law in Oregon, at least for the purposes that it's being used. There are some cases that have determined what it means, but maybe that case law either can't be or isn't being followed in a way that is even fair to ask the police department. Police department sees, hey, he's interfering with me. I'm going to arrest him. This is getting in the way of my ability to do my job. The DA is saying, no, got to toss. We're not going to prosecute these cases. The mayor's in charge of the police. The mayor's the commissioner of the police, and he has a whole different view of both the DA and the police. So we got to all sit down together, folks, and we got to make sure going forward, we can't blame any of this on the police specifically. We can't blame it on the president. Hopefully he'll be out of office. Sorry about that. But on, one of the questions that we didn't get to is what's going to happen 5 years down the road? How are what's going to happen to the First Amendment? Let's start now. Let's sit down at the table and figure out what policies need to be changed, because that's what these protests are ultimately at the end of the day all about. What are we protesting? We're protesting that there hasn't been adequate police accountability, that there's police brutality, that there are social injustices, the police haven't been properly trained in cultural competence and in bias training. There's so darn much to do. So thank you for offering to volunteer to help, to take these jobs that are in public service. Please come to work in public service. We need you so badly. So I look forward to working with you. I'm going to be more involved in this section of the American Bar Association because I think it's doing the best work and we have the best shot, especially in the legal profession, if we have a strong section of civil rights and social justice. So thanks for including me today.
Thank you. Ahmed, would you like to go next?
Sure. It's been a pleasure to be a part of this, and it really just encourages me to see everyone focused on these issues, and I think we all need to stay focused on them. As Roy was speaking, I was just thinking, this is a little bit of an offshoot or an ancillary issue to the First Amendment stuff, but I think that the planning and the procedures and everything that we heard from him and from the other panelists here, including what the AG just said, ultimately isn't going to make a difference until we see a change in people. And I'm thinking in particular about what we saw happen in Rochester, right? We saw it, the police officer in Rochester push that older gentleman down and injure him. And then the police report said that he tripped and fell. We know he didn't trip and fall. And there's no conversation that we can really have, I think. There's no policy that we can really implement that is going to up front change the inclination of police officers and some individuals to do the wrong thing. I think most important of all from this, we have to protect these rights that are so important, because it's only by shining a light on this, it's only by the videos that we see people recording that there's really going to be change, honest conversation, and serious change. I appreciate the time. Thanks, everyone. You've done a great job on this panel.
Thank you. Scott.
Thank you. And also thank you for running a great panel, and thank you for including me in it. And I really appreciate all of the other panelists' comments and everything that I've learned. I guess I wanted to pick up on a theme of Ahmed's about that the laws and the policies are only as good as the people implementing them. We need comprehensive education, and we need a national commitment to these rights. If we do not work for these rights, if we do not take these rights seriously, both in designing the policies and in implementing them, and in appointing the people who will implement them, and in electing the people who will implement them, then they will die from disuse, or from apathy, or from being twisted beyond recognition by our leaders. So we, the people, must hold our leaders accountable to the basic ground rules that our Constitution sets out, and all of the practices and laws and procedures that follow from them to keep our society within those basic constitutional norms. And at this time, when I think there are grave threats to our constitutional values on so many levels, the active participation and oversight and standing up for your rights, whether the First Amendment rights or your rights, equal protection of the laws, has never been more critical. So thank you.
Thanks very much. And Roy.
First of all, a huge thank you to you, Claire, and to Steve for the invitation and for moderating this panel, and to Ahmed, Scott, and General Rosenblum. It's been an absolute pleasure to be with you. I think what I simply want to say is we need to put this in perspective, in the perspective of history. As absolutely awful, and this is something that I do as a civil rights lawyer, as awful as things seem for so many at this moment, I look at the work of John Lewis and Martin Luther King and Thurgood Marshall, and where our country was during the civil rights era, and what those protesters were facing, and what those legal advocates were facing, and the bravery of the country's attorney general to step into the middle of the, I believe it was the Montgomery bus boycott, and risk his life to ensure that those individuals had the right to do, not the Montgomery bus boycott, I think it was actually the freedom rides, and step in the middle of those. And so as absolutely horrible as things seem in so many ways at this moment, this country has been through worse, and people have fought against worse. And so that should give all of us the courage to continue to protest in whatever way we protest, to fight in whatever way we fight, whether that is in the courtroom, whether that is in the streets, whether that is in the voting booth. And we just have to, we have to continue to do that, because the only way our country gets better is for those who care enough about it to speak up and speak out and to protest. So that's what I would say. Just keep protesting.
Thank you, everyone. Thank you again to the ABA section of Civil Rights and Social Justice and the Washington College of Law Program on Law and Government. Claire, thanks for putting all the time into helping organize this and moderating. And panelists, this was just remarkable. I think we all learned a huge amount. It's a little frightening, some of the things we've heard, but you know, the First Amendment, I think, as people have intimated, like other rights, the First Amendment is only as strong as the people that uphold it and work to enforce it. And we are grateful for all that all of you are doing to do that. So with that, happy Constitution Day, and thank you, everybody. Thanks for being here.
Thank you, everybody.
Thank you. Take care.
Thanks for having us. Bye-bye. Thanks for attending, everyone.